Hello everyone, I'm the Masked Analyst. A while ago I recorded a video on the purpose of copyright law. I'd intended on making several follow-up videos at the time, but let's just say that events got in the way. I'd like to continue that discussion today, and I'll talk about the fair use doctrine. Before going into that though, I'd encourage any of you who haven't seen my original video to go and take a look at it. It will help make what I say today and in any possible future videos more understandable. I'm going to sum up what I said in that first video though in just a few sentences. The purpose of copyright law is not to enrich the author or creator of the work or to give him or her control over their work. That's just the means toward a greater ends. And the ends, the main function, the purpose, the reason for copyright law, envisioned by the founders of our Constitution, of our country, is to provide an environment in which more works are created, in which knowledge is expanded and built upon. Now, those who wrote copyright laws originally, they understood that there was an inherent conflict or a tension within the law. On the one hand, you want to give authors the ability to control their works, to make a profit from their works, and thus further stimulate them, to give them an incentive to create new works. On the other hand, almost all works, or most works, are built upon previous knowledge, upon what others have already created. And we need to be able to build upon previous works, to borrow from previous works, to cite from previous works in order to either criticize them, point out their flaws and weaknesses, or to use them to build something new, something totally different. And so there's a conflict between giving the authors control over their works on the one hand and telling them that they have to be able to let others use their works to build on that on the other hand. So there's a conflict, a tension within the law, if you will. And traditionally that tension has been resolved by the fair use doctrine. Now, what is fair use? Well, judging by the name, you would say, well, if someone uses my works and they're fair about it, if they don't use it in a way that's outlandish or that doesn't criticize me or make me look like a buffoon, then it's fair. Okay, that's what it sounds like. But that's not what it means, not at all. Fair use is a term for a legal doctrine which determines when you can copy and use someone else's work. It provides a defense if you're hauled into court and sued for copyright infringement. Now, if you follow the fair use guidelines, that's not a guarantee that you won't be hauled into court. You still might be subject to litigation. Unfortunately, whether you like it or not, in America at least, people have sued just about anyone for just about anything, and there are many frivolous lawsuits in this country. However, if you are brought into court, it does provide you with a defense. It's called an affirmative defense. The burden of proof will lie upon you as the defendant once you're charged with copyright infringement. The burden of proof will will require you to raise an objection once they've shown that you have indeed copied work that was within copyright. However, the fair use doctrine will provide you with a defense. And hopefully, if the judge sees that it is a totally frivolous lawsuit, that what you found obviously fell within fair use, you'll be rewarded the legal fees that you incurred. Now, before I go on, let me make the obligatory disclaimer that I'm not a lawyer. So don't rely upon this for legal advice. If you are really thinking of relying on anything I say as legal advice, I would advise you to do something safer. Like, say, play with matches in a dynamite factory. Okay, so what is fair use? Fair use is defined by Section 107 of the Copyright Law. I'll provide a link to this law in the sidebar, and I'll provide several other links to other articles that I found useful in preparing for this video. I encourage you to go and read those articles if you want to learn more about the copyright law, learn it in a little bit more detail than I'm going into here. Now, Section 107 of the copyright law states, the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, or research is not an infringement of copyright. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include, and then it goes on to enumerate 4 different factors that are used to balance, to determine whether a particular usage is fair. I'll go into that 4-factor test in a second. First, I want to note, though, that the courts have expanded what fair use is a little bit beyond those particularly enumerated items. In addition to being news reporting and commentary and that sort of thing, fair use will also include parodies. Now, it's important to understand the difference between a parody and a satire, because the courts are more likely to find fair use in a parody situation than in a satire situation. In a parody, you're taking someone else's work and you're using it in order to criticize or to provide commentary or shed light upon that work. In a satire, you're using someone else's work in order to poke fun of or comment on events outside the work that have nothing to do with the work. Now, it's really hard, if not impossible, to parody or to poke fun at a work without actually borrowing or from the work itself. And that's why courts tend to say that if your work is a parody, if it's poking fun or examining the original work, then yeah, go ahead. That's more likely to be a factor weighed in favor of fair use. Now, I'll go into those 4 factors, but keep in mind that courts will use these 4 factors as a balancing test. You can't say that one factor is automatically more important than the other. It may vary in from situation to situation as to which factor the courts will say is most important. In some instances, one factor may be by far more important than the other 3 factors. In other instances, the factors may all weigh relatively the same. So it's a case-by-case basis. Now, the first factor to be considered is the purpose and the character of use, including whether such use is of commercial nature or is for non-profit educational purposes. In other words, are you about to make a buck off of someone else's work? If that's the case, then the court is less likely to view this as fair use and is more likely to say that this is copyright infringing. The court will also weigh, what is the purpose of this? Does it fall within the enumerated categories of say, news reporting or commentary or any of the other categories that I mentioned? If so, then it's likely to be considered fair use. If it's not falling within those categories, say it's for pure entertainment purposes, then it's not as likely to be fall within fair use. And then finally, perhaps the most important thing is the use of the material derivative, or does it really build something new? Or in other words, is it transformative? Does it create a totally new work? If you're doing something like maybe drawing a mustache on a video or something like that, that's more or less derivative. You're just trying to do something to make it look like there's some sort of change without making any substantial change, and the court's not likely to say that that's a fair use. If it's something substantial, if you're criticizing the work or taking it to build something new, like a lot of the mashups that I see on YouTube and elsewhere, where they take pieces of different works, different musical works, and they build something entirely new, that's transformative, and a court is more likely to see that as fair use. The second factor that the court will weigh is the nature of the copyrighted work. If it's an informational work, for example, a newspaper article or some sort of reporting or a factual article, then the court is more likely to say that that is fair use, that you can use that work. If it's something like a piece of music or pure entertainment, then the court's not as likely to say that that's fair use. They're more likely to say it's infringing upon copyright. court will also weigh whether the use was previously published. If it was previously published, then the court's more likely to say that it's fair use. If it's not previously published, if it's an unpublished work, then the court's more likely to say, well, you know, there's a reason why it was unpublished. Perhaps the author of the work didn't want the world at large to see it. So they're less likely to view this as copyrighted. The next factor to be weighed is how much of the work you're using. Are you just using a little bit of the work? Or are you using a large chunk of it? Are you using the entire piece? If that's the case, the more you use, the more likely the court will find that you're infringing upon copyright. If you just use a little, you're more likely to be safe. Now, unfortunately, I can't give you a hard and fast rule. I can't say that you can use a minute of someone else's video. I can't say you can use 5 paragraphs of someone else's written work and say that that's fair use. Obviously, it depends on how large a work it is originally that you're copying from. If you copy 1 minute of a video from a video that's 1 minute and 5 seconds long, the court's much more likely to view that as infringing upon copyright than if you copy 1 minute from a 2-hour documentary. I can't, unfortunately, even give you a hard, fast rule as to a percentage that's allowed. In some cases, there's one case that I know of that you can copy an entire work and it won't be copyrighted, a copyright infringement. And that's a situation of time shifting. You can use your VCR or DVD recorder and copy a television show for your own private use later on, and you're just shifting the time in which you're watching the show. That's okay. On the other extreme, it's possible to quote just a very tiny portion of a work and be found to be infringing on copyright law. There's one case in which 400 words were copied from a 200,000 word memoir by Gerald Ford, and the court found that that was a copyright infringement because it quoted or took the very heart of the article. So there's no hard and fast rule. But that's the third factor to be considered by the courts. And the last factor, and probably this is the most important factor, is the effect upon the potential market of the original piece. If you're borrowing from the piece, and if you're going to be using that in a way that will decrease the sales of the original work, then a court is likely to find that as copyright infringing. You're hurting the author. You're providing a disincentive for authors to produce new work. So that would be going against the purpose of copyright law if you take away an author's sale. Now, there's one situation in which this isn't really a factor. If you're using the original work to criticize on the work, and by the purpose of your criticism, you sort of devalue the work. If you poke holes in the work, if you basically make the author look like a buffoon by showing how totally ridiculous his work is, well, that's legitimate criticism. That the court will usually view as legitimate criticism. And so that wouldn't necessarily be a copyright infringement. But if you're using this as a substitute, if you're going to the market and whether you're making a profit on it or not, if it's providing a substitute for the original work, people won't buy the original work because of your copyright, because of your copying, then the court's likely to view that as a factor weighing toward copyright infringement. So those are the 4 factors. They're weighed one against the other, and there's no hard and fast rules to say that this is copyright infringement, this isn't. Now I'd like to take a moment to discuss the difference between plagiarism and copyright infringement. A lot of people seem to confuse the matters. They seem to think that it's okay for them to take a video and repost it, and so long as they say where it came from, they give props to the author, to the creator, that they're off the hook, that it's not a copyright infringement. Wrong! No, it doesn't work that way. It will prevent others from accusing you of plagiarism. Plagiarism is the taking of another person's work and making it look like you're indeed the author or the creator of the work. and it's a totally despicable, unethical practice. And if you cite someone else's work, and you should cite someone else's work whenever you copy from it, then you won't be guilty of plagiarism. But that has absolutely nothing to do with copyright. You can give all the credit in the world to someone else's work. You can scream it from the roofs that hey, Seth MacFarlane was the creator of Family Guy, not me. So if I posted this Family Guy, that's cool. No, you can scream that from the roofs all you want, but that's not going to get you off the hook. So don't confuse that matter on those two issues. Now, the fair use doctrine is a reasonable approach to copyright law. It furthers the ends by providing an environment which will provide an incentive for authors to create new works, while giving others the freedom to cite the works and create and build new works. It's the way that copyright law should be. Unfortunately, the people who run YouTube and a lot of internet sites are thumbing their nose at fair use doctrine. Fair use doctrine is not the law of the land on YouTube, whether you like it or not. Now, this isn't entirely YouTube's fault. It's partially YouTube's fault, but it's not entirely YouTube's fault. YouTube is following guidelines set by the Digital Millennium Copyright Act, or the DMCA. This is largely Congress's fault. Although, and I'm not going to get into it now, YouTube does not escape totally without blame for the fact that they decide to throw fair use out the window. Now that's for a discussion in another video some other time. This has been the Masked Analyst, under and in.